In the early morning hours of Thanksgiving, a resident of Huntington, Vermont was awoken by a gunshot close to his home on Heinsberg Hollow Road. The concerned resident called the state game warden to report a possible deerjacking.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
I thought we would start with a Thanksgiving-related story that I wanted to read this story about this thing that happened because it relates to Thanksgiving. It's kind of outdoorsy and Thanksgiving-y, but only in a dark way that only awful masses could present to you. And so let's take a look at the state of Vermont versus Clyde S. Bovat. This was appealed all the way up to the Supreme Court of Vermont, which I believe is the highest court in Vermont, unlike New York, which has the Supreme Court as the lowest court in the land, which is just weird. Of course, New York's just weird. This is a case of deerjacking. Defendant Clyde Bovat was convicted of shooting a deer in violation of Vermont big game hunting laws and failing to immediately tag the deer. On appeal, he claims the trial court erred in denying his motion to suppress evidence, allegedly obtained in violation of his constitutional right to be free from warrantless government intrusions. For the forthcoming reasons, we affirm the lower court's judgment. So they are going to deny Clyde Bovat his motion trying to suppress evidence. So this is going to be a case of constitutional Fourth Amendment right to be free from unconstitutional search and seizures. In the early morning hours of Thanksgiving 2017, a resident of Huntington, Vermont was awoken by a gunshot close to his home on Heinsberg Hollow Road. The concerned resident called the state game warden to report a possible deerjacking. The warden arrived at the scene and spoke with the resident, who advised that the gunshot woke him shortly before 4 a.m. and it rattled his windows. The resident said that he looked out his window and saw a dark-colored truck with running lights on top. A preliminary search by the warden revealed no evidence of a deerjacking. The warden returned later that morning at approximately 7 a.m. to inspect the scene more closely and located deer tracks along the southern shoulder of the road. I mean, the warden is like a tracker at this point. The warden's going to investigate by finding the animal tracks. That's just amazing. That's just really cool. That like outdoorsman survivalship stuff has always fascinated me. At the approximate location the resident had described seeing the truck parked, the warden found what he believed to be deer hair and blood. He collected samples for evidence. In the course of the investigation, the warden interviewed E.S., who reported shooting a 6-point buck at 7 a.m. on Thanksgiving morning in Heinsberg. After some equivocation, A.S. informed the warden that he had not shot the deer, and that defendant had sold him the deer carcass at Clark's barn. Clyde Bovat, so it's not Clyde's barn or Clark's barn, wherever that is. The partially butchered carcass was seized as evidence. Then the warden, along with other law enforcement officers, went to defendant's residence to investigate further. Law enforcement officers proceeded up defendant's driveway to the two-bay detached garage. This is important because it's going to come into the search and seizure part of it. Through a window in the garage door, the wardens observed the rear tailgate and license plate of defendant's black pickup truck. The wardens also saw what appeared to be deer hair and blood on top of the truck's rear tailgate, which was approximately 1 arm's length from the warden's vantage point. As the tailgate was closed, the wardens were unable to see into the bed of the truck or the interior side of the tailgate. The wardens went to defendant's front door, spoke with his wife, and asked for her permission to enter the garage. Defendant's wife said that she couldn't find the key and was unable to open the garage door. Based in part on their observations through the garage window, the wardens obtained a search warrant to seize defendant's truck and collect samples of blood they had observed, which matched a sample from the deer at issue. They did not photograph the truck until approximately 5 days after the seizure, during which time the truck had been left outside in inclement weather. Due to exposure of the elements, a smaller amount of blood than originally observed was visible, and the deer hair was no longer visible. Prior to trial, defendants sought to suppress the evidence obtained through the search warrant, arguing that 1. His garage falls squarely within the curtilage of his home and is protected from warrantless government intrusions. We'll get to curtilage in a moment. 2. Law enforcement had no lawful basis to peer through his garage window, so no lawful basis. 3. Even if the garage is not within the curtilage of his home, sufficient steps were taken to exclude its interior from public view. 4. Absent the unlawful intrusion into his garage, there is no probable cause to issue a search warrant, and the evidence obtained must be suppressed. 5. The warden included false and misleading statements as well as material omissions in his affidavit of probable cause. The trial court denied the suppression motion. The court held that the garage, which is isolated a significant distance from the home, separated by a row of trees, and a small stone wall, was not part of the curtilage. So that's important. This is not a home where you walk out the door from the kitchen and you're directly into the garage or something like that. And the garage is attached to the house and is part of the house structure. This is a separate garage, separated by a row of trees and a small stone wall. Now, I'm not concluding whether that's one thing or another, whether that's curtilage or not, or home or not, or Fourth Amendment or not. Let's see what the court has to say. However, the court noted that even if the garage was part of the curtilage, the warden had a legitimate right to be on defendant's driveway, and the garage window was in plain view, emphasizing that the wardens entered the driveway to conduct legitimate police business. On appeal, defendant argues that the court erred in denying his motion to suppress because 1. His garage is within the curtilage of his home. 2. His truck's tailgate and license plate were not clearly visible from the lawful public vantage point. And 3. The warden included a false or misleading statement and material omissions in his affidavit in support of the search warrant, which constitutes some kind of violation that the court is not going to go over. We agree with the defendant that his garage is within the curtilage of his home. So there you go. It is within the curtilage of his home. We are unpersuaded by his remaining arguments, though. The wardens were conducting a legitimate police investigation during which they observed defendant's truck in plain view from a semi-private area. Accordingly, we affirm. When reviewing a motion to suppress, we review the trial court's factual findings for clear error. The trial court's findings are upheld unless there is no reasonable or credible evidence to support them. In other words, the trial court is the fact finder, and the appeals court is only going to change things if there is really no evidence to support the fact finding. If the trial court's findings are not clearly erroneous, which is the legal standard, clearly erroneous, we then review the legal issues brand new. So they're only going to be reviewing legal issues if they can't find any factual issues. First, defendant argues the trial court erred in concluding that his garage is not in the curtilage of his home. Yes, this was error. Curtilage is defined as the land immediately surrounding the home and associated with it into which the privacies of life may extend. The United States Supreme Court has identified 4 factors to aid in determining if an area is curtilage. 1. The area's proximity to the home. 2. Whether the area is within an enclosure surrounding the home. 3. The nature and uses to which the area is put. And 4. The steps taken by the resident to protect the area from observation. These factors do not produce a finely tuned formula that can be mechanically applied. Rather, they bear upon the central consideration of whether the area in question is so intimately tied to the home itself that it should be placed under the home's umbrella of Fourth Amendment protection. Vermont adopted the Dunn factors, which were the previous site that what we just said there was the Dunn factors. They adopted those factors in State v. Hall and applied them in Rogers. Great. If you're not a lawyer or law student, trying to remember case names is tough. It's even hard for lawyers too. The Dunn court found that the barn in that case was a substantial distance from the house, 60 yards away, It did not lie within the area surrounding the house that was enclosed by a fence. Law enforcement had objective data that the barn was not being used for intimate or private activities of the home, and the defendant had done little to protect the barn area from observation by those standing in the open fields around the structure. Based on these findings, the court concluded the barn was not within the curtilage of the home. Following the Dunn analysis, this case calls for a different result. First, defendant's garage and home are in close proximity to one another, separated only by an area of driveway that can accommodate approximately 2 vehicles and plastic garbage bins, and a small row of trees. While the trial court found the distance significant from viewing aerial photographs admitted at the hearing, the photographs actually depict a continuity of space with a walking path to the house from the driveway. Second, a low, white, split rail fence stands along the road, but as the trial court found, it does not enclose anything. It begins along one side of the driveway and continues off toward an open field away from the residence. The fence does not separate the garage from the house in any way. Third, defendant uses the garage for domestic purposes, parking his vehicles and storing his hunting equipment. Finally, while defendant does not prevent observation of the garage itself by placing barriers or no trespassing signs, the garage door was closed and locked. The garage is properly considered to be within the curtilage of the home. We have held that curtilage includes outbuildings such as sheds and garages used for domestic purposes. Here, defendant's garage merited the same constitutional protection from unreasonable searches and seizures as the home itself. We nonetheless conclude that the warden's plain view observations through the window of the garage from a place he had a right to be did not violate defendant's Fourth Amendment rights. Let's stop there and ask our in-studio people, what do you think so far? Do you believe that the garage is within the curtilage of the home and should receive the kind of protections that a home receives in a Fourth Amendment search and seizure inquiry?
I think so, yeah, because I mean, some people live in their garage, some people have, that's an extended part of their living quarters even.
Yeah, like I just really don't hear any way to argue against that. That certainly seems like he used it as his regular garage. My garage is detached, so I'd have the same problem, but I don't have a window into my garage. And I rent my garage out to a neighbor anyway. But what they're saying is, so the difference here, just to make the distinction, the difference is there was the case with the barn. The barn was a little farther away. The barn wasn't used as a personal garage. And so it was not considered to have the same level of Fourth Amendment search and seizure protection, which means the police, and in this case, the wardens, could pretty much just go up to the garage, look around, take pictures, gather evidence for their investigation. Whereas here, there has to be a different reason. That can't alone be the reason why they were able to get a search warrant. If that alone was the reason they got a search warrant without more, they would not be able to get the search warrant. And we're going to hear that there was more because they've already revealed that they affirm the lower court. So they get the search warrant and they don't have to suppress the evidence. But why is the big question? In State v. Koenig, we held that Fourth Amendment protections extend only to items which are not in plain view and cannot be seen by persons from a place they have a legitimate right to be. That plain view exception applies here. The plain view doctrine is grounded on 2 principles. First, that when a police officer has observed an object in plain view from a legal vantage point, the owner's privacy interests are forfeit. And second, that requiring a warrant once the police have obtained a first-hand perception of the object would be a needless inconvenience. Regarding the first prong, that the police officer observes the object from a legal vantage point, we have previously stated that police officers are entitled to enter residential property, including portions that would be considered part of the curtilage, to carry out legitimate police business. Portions of the curtilage, like driveways and walkways, which are normal access routes for anyone visiting the premises, are considered semi-private places. When state officials restrict their movement to semi-private areas to conduct an investigation, observations made from such vantage points are not covered by the Fourth Amendment, or not suppressed by the Fourth Amendment. In other words, a private area may still be open to visual inspection from a semi-private area. Here, while the garage itself is a private area that the police would not have been justified to enter without a warrant, the wardens restricted their movements to defendant's driveway, a semi-private area, where they observed what they believed to be incriminating evidence on defendant's truck. Because the wardens observed the truck from a legal vantage point, the first part of the plain view exception is met. An object must also be in plain view. Where the government observes that which is willingly exposed to the public, there is no invasion of privacy. A person can reassert privacy interests in semi-private areas by posting no trespassing signs or erecting barriers to apprise others that the area is private, like a fence or not a window. When a landowner has taken steps to indicate that strangers are not welcome, such that a reasonable person would conclude that the public is excluded from the land, an expectation of privacy is reasonable. However, absent evidence of intent to exclude the public, and when the police officer can readily observe the object from a lawful vantage point, the plain view requirement is met. This is true here. Defendant urges us to analogize the present case to State v. Ford. We declined to do so. In Ford, an officer performing a welfare check walked around defendant's house, bent down to a basement window, saw marijuana plants under a grow light through a gap in the curtains. However, that case looked at whether the emergency aid exception applied under the facts of the case and did not address the plain view exception at issue here. Moreover, there was no claim in Ford that the officer saw into the basement window from a semi-private place that was a normal access route for visitors to the premises. We are also unconvinced by defendant's argument that his detached garage with closed doors connotes a reasonable expectation of privacy. Defendant did little, if anything, to indicate that expectation. As the trial court found, the garage was not in an enclosure. Defendant posted no signs, erected no large barriers around his garage, and, as the trial court found, the small white split rail fence does not protect the area from observation in any way. The windows in the garage doors were not covered or blocked or frosted that was my suggestion, frost them in any way. An adult standing on defendant's driveway could see into the interior of his garage where his truck was parked because nothing was done to prevent somebody from seeing into the garage from the driveway. So here's your legal advice from this stream or this VOD. Get that window tint frosting stick-on stuff, or the spray, or the glass etching stuff, which is a lot more permanent. But even just a stick-on, just something to frost the glass and protect outsiders from seeing in. If your windows are on a public access route like mine are, I live in a row home on a public street, and people could see into my windows. And that's what I did. I went and got the fake window frosting, plastic stuff and put it on. And if you come around, it looks terrible because I'm not very good at putting it on, but it's just for privacy while I'm waiting to get ready to put up new windows anyway. This whole house needs to be renovated, and I'm just doing it one piece at a time. Defendant also relies on Collins v. Virginia, where an officer investigating a traffic infraction and theft uncovered a suspect vehicle from under a tarp on a defendant's driveway without a warrant. The officer removed the tarp, ran the license plate number, and photographed the uncovered vehicle. The United States Supreme Court in 2018 held that the officer's actions did invade defendant's Fourth Amendment interests in the curtilage of his home and the vehicle searched. Collins, however, concerned the automobile exception to the warrant requirement, not the plain view exception. Furthermore, the warden did not move or uncover anything to see defendant's truck. Therefore, we find defendant's reliance on Collins misplaced. For the foregoing reasons, we conclude that the plain view exception to the prohibition on warrantless searches and seizures applies. Accordingly, the trial court correctly denied defendant's motion to suppress, affirmed. And there is a dissent. The dissent is actually longer than the majority opinion, but we're going to go over it quickly. I've highlighted it out a little bit. The dissent says, I disagree. In my view, the majority's analysis undervalues the deeply rooted legal and societal principle that the coveted privacy of the home should be especially protected. In addition, the majority has misapplied the plain view doctrine and the knock and talk exception, resulting in a bright line rule that permits law enforcement officers to freely wander and observe while on a person's driveway without reference to the particular circumstances of the search. Based on the facts of this case and our principles of search and seizure jurisprudence, I would reverse the decision of the trial court and grant defendant's motion to suppress. Accordingly, I respectfully dissent. We have long held that the reasonable expectation of privacy and thus a person's protection against warrantless government intrusion is at its highest in the home and its curtilage. Both the garage, the area the game wardens observed, and the driveway, the area from which the wardens made their observation, are part of the curtilage of defendant's home. This presumed protection is not absolute, and warrantless searches may be permissible if an exception to a constitutional protection applies. As the majority explains, the plain view exception depends on an object's being in plain view from a lawful vantage point. Here, law enforcement officers made observations from within the curtilage itself. The observations cannot be considered in plain view unless the officers have lawfully intruded into the defendant's curtilage to the point of observation. The plain view and knock and talk exceptions may work together to allow law enforcement officers to enter private property to conduct an investigation or for some other legitimate purpose, and then once there, officers' observations made from such vantage points are not covered by the Fourth Amendment or Article 11. When officers enter private property in this way, they must restrict their movements to places visitors could be expected to go: walkways, driveways, and porches. Contrary to the majority's representation, this court has never held that knock and talk exceptions categorically allow law enforcement officers to enter a person's driveway for legitimate police business. Following a related line of reasoning, some courts have held law enforcement officers' actions unconstitutional even when the officers adhered to the public's usual route of access if the officers nonetheless exceeded their implicit license to enter the property. Here, the trial court found that the game wardens went to defendant's residence and approached the residence via the driveway, and at one point, both wardens looked into defendant's two-bay detached garage that was located at the back of defendant's driveway some distance from the road, through a window in the garage door, and observed defendant's black pickup truck parked in the garage. The court made no findings about how large the window was, how close to the window the wardens stood when viewing the truck, whether the wardens looked through the window before or after approaching the residence, or at what point the wardens attempted to contact the residence's occupants. The findings do not establish that the truck was in plain view from a public vantage point. On the contrary, the findings establish that the truck was not in plain view from the public street or from a portion of defendant's property outside of the curtilage. In order to bring the truck into view, the wardens had to enter defendant's driveway, which was part of the curtilage and, therefore, a constitutionally protected area. Because the place of observation was within the curtilage, the truck could not be considered publicly exposed unless the state showed, and the trial court found, that the wardens came to the point of observation and made the observation in the same manner as a reasonably respectful member of the public. The findings do not establish this. And that is the dissent of the Chief Justice. So what do you think? I agree with the majority, I think, because there was a window and it's the driveway. Yeah, you can walk up the driveway and look in the window. I think that's a reasonable thing to expect people to do when you have a driveway and a garage. But it's also true that I didn't see details. Maybe the driveway was 1,000 feet from the road. If it was not, if it was 10 feet from the road, it's different. There was a fence that was right against the road, though, so maybe it wasn't that far from the road. And that was Chief Justice Reber, by the way. So the Chief Justice lost on that one. What do you think of that? So that is the curious case of deerjacking. The curious case of the Thanksgiving deerjacking in the state of Vermont. So that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. This is Lawful Masses, your favorite legal education and legal news channel. Our channel is growing. We now have Brandon editing our videos full time. I do screenings and thumbnails and other channel management, plus the production. Tactical helps write and helps manage. Joe helps write and helps manage. All of these people deserve to be either paid a living wage or recognized for their support. And so thank you very much to all of you for your support. In the month of November, the $50 plus supporters are Joe Tyson, Aspernari, John Steele, Gavin Barnard, Evie, Kyle Mudrock, Michael Pierce, Spirit Bear, Jan Negre, Daniel Perez, Snorre W, Blackleaf, Benjamin Hightoff, and Steven. And thank you to the $5 plus supporters scrolling on the LED panel behind me and the crawl of the videos that drop. I'll put some dog video here for you to watch. Enjoy. We love you. Have a great Thanksgiving, those of you who are celebrating in the United States and elsewhere. And well wishes to you and yours, everyone, everywhere, anyway. I'm Leonard French, your favorite copyright attorney. Love you all. Bye.